Swayam Prabha. Digital India. Educated India.
Welcome students to another class of Introduction to Political Theory. Now till now we have mostly covered the ideas of equality, idea of liberty, equality of justice, and for that matter today we are going to study about idea of right. If I say particularly that I have the right to probably have an ice cream, which would not just mean that I can go or I have the liberty to have an ice cream, but it would also mean that this right has to be protected in order for me to exercise this right in the first place. So then it would mean that if I say that I have a right to something, which would not essentially mean that I have a right from something. Now if I say that A is free to become something from B, which is basically I am telling that A is free to exercise its right to become something, say a doctor, from B. Now B could be the state which could prevent A from becoming something. Okay. Now if I am saying that, I would definitely mean that this particular person A has the right to choose whatever career he or she wants, which would basically mean that B cannot stop this person from choosing his or her career. Okay. Now if I have to say that particularly A has the right to be something and not to be something, then I am basically specifying areas where I can do something, which is basically I have the right to something, and also I have a right from something, which basically means that what I can do and what I cannot do. So then I am differentiating. Now this concept of right, which we actually see very much accessible to us in everyday life. I have the right to liberty, I have the right to speech, I have the freedom to roam freely in the country, I have the right particularly to form associations, and of course I have the right to life with me. Now these rights which we see today has come to us in a normal manner. Probably we never even thought to what extent does this right what we have now would mean if we would have taken birth say 50-60 years ago. Does that conception of right what we have right now would be the same? Probably not. So that is why the idea of right, okay, firstly comes hand in hand with liberty, equality and justice. But how did this idea actually arose? What does this mean? Because in today's time, if I ask you what is a right, you will say something which I generally have. I have the right to live. I have the right to pursue my own career. I have the right to stay with my parents or move away from them after 18. I have the right to vote after 18. But this is not what exactly rights mean. These are basically to some extent your natural rights, your personal, your individualistic rights, or for that matter your political rights. But when we talk about particularly moral political philosophy, the conception of rights was not taken into consideration as just the legalistic form. Okay, this conception of rights covers a varied areas and has been presented by different authors, and today we are going to see how. Okay. So let's start with this idea of right. Now rights particularly we all know came in through your one American War of Independence and secondly your French Revolution, where you have these particular notions of liberty, equality and fraternity also coming up, and also this right to life coming up, because till now we had something called slavery existing in our society. So when this revolution happened, the first right we got was particularly right to life. Now this right to life is considered to be natural now, but at that time it was a right we had to basically fight for in order for us to have. Now, this could also be seen when we were fighting for our own independence, that the Britishers had killed nearly most of the Indians just on the basis of that they were fighting for independence without any trial, without any justice. So, then it would mean that the rights which have come to us are not something which were given so naturally to us as a part of human existence. Okay. So, let us see that the Declaration of Independence, that is the American War of Civil Independence 1776, which happened in United States, certain rights are inalienable. They were at the forefront of a moral movement that constitutes to exert a profound impact on the society even today. Indeed, at the same time, the French were also developing their own equivalent Declaration of Rights of Man and of Citizen. Thus, the two most influential political documents of modern age take the notion of rights as central concepts upon which their political organizations are built. Now, if you read this line very carefully, that there is a declaration of rights of man and of citizens. Now, in this particular statement itself, we basically differentiates between rights of a man, that is what we owe or what we should be having in the form of a rights as just being a human. Now, here we differentiates not just from citizens, we also differentiates from particularly animals. Okay. Now, the kind of rights which a human deserve does not necessarily believe that the animal kingdom also deserves certain kind of rights. So, now we are differentiating in terms of rights which humans intend to have, and from that also we are differentiating the certain kind of rights citizens have. Now, particularly everybody staying in India, whether they are foreigners, do not have the right to vote. Why? Because they are not the citizens of this country. Similarly, there are certain kind of educational rights or right to free education which might be provided to even foreigners. Why? Because those are the certain kind of rights which Government of India provides not just to its citizens but also to foreigners. So, then we can differentiate the certain kind of rights which we achieve as being humans, that is basically universal in nature, and certain kind of rights which we receive as being citizens of a particular country. Okay. Thus, the two most influential political documents of modern age take the notion of rights as the central concepts upon which their political organizations are built. Now, this political organization is nothing but the state. Okay. The interest in rights was not restricted to 17th and 18th century only. The second half of 19th century also witnessed a major resurgence of interest in the notion of human rights. More recently, issues about rights of women and disadvantaged minorities have been a matter of debate. Now, if you see that the rights what we have now was not the same 50-60 years ago, which would mean that this whole conception of rights arose by simply having the right to life, okay, which was a natural right. Then came certain kind of rights which, when people wanted to demand being a part of this political institution called state, which is the right to vote. Okay. Now, there is basically a chronological order in which we see that these rights have evolved over the period of time. It started with the very basic right of particularly right to life. It moved from that century, from 17th, 18th century, particularly towards a something called political rights. Okay. Now, in most cases or in most books, you might confuse yourself with political and civil rights. Now, what used to happen is that because the civil society was considered to also be a part of this political society, hence the rights was designed in such a manner that they would be basically promoting the political acceptability or particularly political accessibility in the system in the form of rights, which does not mean that civil rights and political rights were the same, but to some extent they were considered same in a particular area. Okay. Now from these political rights, we particularly move to the third generation of rights, which is known as human rights. Now this is basically certain kind of rights which evolved over the period of time. Why? Because we can say that just as justice or liberty or equality cannot be universally applied in its definition, there is always a part where we say that there is some kind of differentiation, whether it came with equality. If you remember, there was a differentiation in the treatment, that unequal should be treated unequally, in the sense that people who are basically of or have some kind of disadvantages should be treated accordingly and not along with the same population. So similarly, these kind of rights also arose, like your multicultural rights, okay, your national identity rights, especially in the form of refugees. Now if you know that when particularly India became independent, there was a lot of refugee crisis in India itself. Why? Because people were coming, and because of the partition there was lot of movement happening on the borders. Now does that mean that those people who came to take a refuge in this country would never be considered citizens, would never be able to gain those rights? No, that's not the case. That is basically what this second generation or the third generation of rights were trying to achieve, that in the form of human rights, there are certain rights which should be granted to each and every individual in the society in order for them to actually exercise those rights. Okay. Now then we come to basically differentiating between what is this idea of rights and how did it evolve. Okay. Now what is a right? A right is simply said to get one's dues. What am I due? Basically, if I am a human being, there are certain rights which I should get as a human being. There are certain rights if I am a part of a community, there are certain community rights which I should be getting. If for example, I am a citizen of one country, as a citizen what are those rights I should be getting? So right is to get one's due, that is to get what is due to someone as a human, as a citizen, as an individual or as a member of the group. To have a right then is to be entitled to do something or to have something or to have something done, for example, to vote, to speak, to avail health care. Okay. Now it is different from obligation, as Hobbes points out. On any occasion you have the choice whether or not to exercise your right. You are not obliged to do what you are entitled to do. Okay. Now particularly when I talk about, it is different from obligation, as Hobbes point out. Now going back to what Hobbes thought as is particularly that there was a state of nature. Now this state of nature according to Hobbes was a state of war. Okay, there was war happening. So remember when I told you that when Hobbes was writing, there was particularly 30 years of Napoleon War was going on, which basically means that people were fighting again and again. Okay, so when Hobbes was writing, he says that people are brutish or people are selfish. They are basically self-centered in the state of nature, and this state of nature is a state of war. Okay. So when Hobbes says that in the state of nature people are just fighting, how would they acknowledge each other's rights? Now they would only be able to acknowledge each other's rights if they come into some contract. Okay. So then came a contract, and according to this contract, every individual will be obliged their life to a particular person, will be obliged to give away this right to life to a particular person which they would consider legitimate to rule them. Okay. And in return this person would provide them security. Okay, security rights. Now in Hobbes' theory of rights, this is an obligation. I am obliged to the state or I am obliged to this person because there has been a contract which is signed. But in contemporary times we do not say that. For example, I have the right to vote, whether I exercise it or not, it is basically my wish. I am not obliged, there is no obligation here. So then rights particularly in contemporary times would not mean as Hobbes used to interpret. Okay. Right must be justified in the first place as something I have as a member of some social group. Second, what I claim as a right must be something which is necessary for me if I am to play my proper part as a member. Third, my claim to have a right as a right justified only if I am able to and willingly respect the rights of other members. Now, this is the same thing which happened with liberty, that my liberty can only be given to me till the time I also respect the liberty of other. So, in that sense, we have basically certain kind of boundaries created with the rights I can exercise. Okay. Finally, to have the right entails certain responsibilities. This brings about the distinction between negative and positive rights, which we will see. Okay. So, let us just review these statements what we have just read. Right must be justified in the first place as something as I am a member of some social group. Okay. Now, again I said that there are certain rights which I am entitled to as a human being, and I am entitled to say a citizen of a country. Okay. So, these are those rights which I am entitled to. Secondly, what I claim as right must be something which is necessary for me. If it is not necessary for me, why would I even want that right, or when will I exercise that right? So, these rights which are given to me should be of some importance to me. Okay. Then it is said that the third, my claim to have it as a right is only justified if I am willing to and basically respecting the rights of others, which we have clearly mentioned. Finally, having the right entails certain kind of responsibilities. Now, what are these responsibilities we are trying to basically focus, because with rights also come certain kind of duties. Okay. So, here we are going to basically form a distinction between positive connotation of rights and negative connotation of rights and what they are. Okay. So, negative and positive rights. Negative rights are rights that entail non-interference from the society at large. Now, if you see your Indian constitution and you see fundamental rights given in part 3, you will realize that all those rights which are given there, some of them would be negative in nature and some of them would be positive in nature. Now, go back to particularly what I taught you when I was teaching liberty, and I told you the distinction between negative and positive liberty. Now, that has to be applied exactly here. When I say negative right, it definitely means that there is no interference from the state or the society in my rights, in particularly my individualistic right. An example of that would be right to life, right to liberty, right to property. The right to life prevents others from killing me, but it does not obligate them to do anything positive to assist me in the living my life happily. Now, this is basically saying that yes, they particularly have no right to interfere in my life in the sense that they cannot come and kill me. But does that mean that they also have an obligation to particularly support me in choosing my career or support me in living my life happily? No, they are not. So, this is negative right, which is just limited to non-interference by the state or the society. Let us see what is the positive connotation. Now, positive rights that impose obligations on the other person or the state to do something for a fuller enjoyment of our rights. For example, right to health, basic substance requires positive interference to do something. Okay. Now, positive rights are particularly right to clean water. Positive right could be right to pollution free air. Positive right particularly to provide free education. Positive right to provide right to work. Now, these are all positive connotations also given in Indian constitution, which basically tells us that these are the kinds of rights which will enhance our living or which will enhance our capabilities to lead a good life. Okay. So, they are not just non-interference, rights are not given to me as non-interference, they are also given to me so that I can achieve a higher self or achieve whatever I have set my goal to. Okay. So, this is basically the difference between positive and negative rights, and this is the third distinction or the characteristic when we talk about that rights come with certain kind of responsibilities. Okay. Now, this is the evolution of rights which has happened within these 3 generations. First came the civil rights, political rights, and then lastly came the social rights. Okay. Now, in contemporary political thought, the term civil rights is in dissolubly linked to the struggle for equality of the African Americans during the 1950s and 1960s. The aim of the struggle was to secure the status of citizenship in a liberal democratic state. Civil rights are basic legal rights a person must possess in order to have such a status. Okay. Now, as I told you that civil rights and political rights to some extent complement each other, or to some extent becomes even synonyms to each other. Why do we say that? We say that because when they were fought during 1950s and 60s, we basically see that they were fought for legality. They were fought to become a part or become the citizen of the country, because African Americans till 1960s were not given these political rights. Okay. So, until the middle of the 20th century, civil rights were usually distinct from political rights. Okay. The former included the rights to own property, rights to make and enforce contracts, the right to legal course. So, it was basically the legality aspects, but it did not particularly include right to vote or right to hold public office. So, that is why in the second part you will see this distinction happens between civil rights and political rights, because earlier civil rights were just concerned with the rights of the property, rights to enforce contracts or be a part of the legal course. Okay. But here political rights and civil rights diverge from each other when you have political rights talking about particularly right to vote or hold public office. Okay. These were the political rights reserved only for males. The claims for which the American civil rights movement in 1950s and 60s initially fought belonged to the first generation of particularly civil rights. Now, this is the first generation of civil rights which is happening. Okay. What is the second generation? Now, these second generation of rights include welfare rights. They argued or they helped to ensure that the political, economic and legal rights are viewed in comprehensive manner. Now, if you remember, it was in 1960s and 70s where we saw that particularly this individualistic conception of liberty, that individuals should be let alone for himself or herself to take care. State should have a minimum role in interference in their lives and also in the economic sphere. Now, this was all happening, but what was the repercussion of it? The repercussion was basically that the whole economic system was failing, because we know that even though individuals can take care of themselves, going by the libertarian view that individuals are rational beings and they can take care of themselves, market should be let alone, but to some extent there will be certain kind of consequences to it, and when that happened, probably there was natural calamities or something or the other happened, it was seen that particularly state intervention was required here. Why? Because we saw that men or individuals as such were not able to sustain on themselves, and there was a need for the state intervention, particularly in the economic dynamics. Okay. So, then we see that this conception of welfare came in, where we see that this all debate about what do we have to do to ensure political welfare, what do we have to do to ensure economic welfare, and also in terms of upliftment of the society, so that people or individuals who have degenerated from a longer period of time, we are able to help them overcome. Okay. So, then there was this conception of welfare rights being fought. Now, the third generation claims that 20th century also received considerable attention in recent years that may be broadly termed as cultural membership. Now, rights of cultural membership, mostly you have seen that there has been wars for national identity or cultural identity being particularly formed. If I have to tell you an example, let us just say an example of East and West. Now, to a larger extent of time, we saw the Western countries controlled not just literature, they did not just control particularly your economic dynamics, your political dynamics, but they also controlled your mind by saying that we as countries are modern, okay, that these particularly the people who are living towards the east should learn from these western countries how to lead their lives, how to basically make their economic system good, or for that matter they also taught us that we were traditional and they were modern, okay. Now this whole conception of traditionality and modernity is also when we see particularly this identity, this cultural identity tries to exert itself. It was only after 1970s or 80s when we saw that the eastern countries also tried to establish their identity, that no, it is not true, we are not traditionalized, but we have our own manner of development and we do not have to basically replicate the development as happened in the industrialized countries for us to become prosperous, okay. So that was not the case. So that is why language rights for members of cultural minorities and rights of indigenous people to preserve their cultural institutions and practices, okay. Now you must have seen that there are revolutions and there are rights being carried along with lot of minorities even in India, and to that extent even reservations when they came, they were basically in order for the upliftment of these minorities who had been historically discriminated, okay. So then we saw that these particular rights, even in the Constitution of India, you will find that languages, different languages have been given constitutional status, whether it is Bodo, whether it is Maithili, okay. All these language has been able to exert itself in the constitution. Why? Because to some extent they wanted certain kind of identity and they wanted the nation to know that they exist. This identity rights has to be given to them. So that is why in areas, if you go in Arunachal Pradesh, if you go in areas of Meghalaya or Mizoram, you would require certain kind of permission by the state, because there are certain scheduled tribes who do not want to be interactive, or there are certain kind of rights particularly given to them. A very good example of this is also certain kind of tribes living in the Andamans, okay, the Nicobar Islands particularly, where government have made a point that normal people, Indian citizens or in general people do not go and visit there. Why? Because the government of India has tried to secure these rights, okay. So this is again the third generation which came as a form of a multicultural ethnic, you can say, or identity rights which came up, okay. Now this is basically the types of rights. The types of rights can be divided, one on the basis of their source, where we have taken them from, and secondly it can be divided from basically the nature of this, okay. So types of rights on the basis of sources, divine rights. Now for a very long period of time when we had monarchy or when we had kings, we generally regarded that these rights were given by God to them, okay. Kings were regarded as particularly God in itself, okay, the Purushottam. Now these divine rights particularly said whatever is king giving to the particularly his population or public is rights. So then we say that these divine rights were considered to be given by the king himself from the God, okay. Then came the conception of natural rights, which basically belong to our nature, that is right to life, for example, that is a natural right which should be given, okay. The third is a fundamental right which is basically coming from the constitution. The fourth is a legal right which the states give us. Now it is the legal right to property which the states give us. It is a legal right to vote, again given by the state. Fundamental rights are basically certain part of rights which are enshrined in the constitution. The last is the moral rights. Now this is a kind of a rights we will basically be studying in detail, okay. So let's see what is the basic difference between legal rights and moral rights. Now laws differ from ordinary life or moral discourse in that the truth of any legal statement depends ultimately on the acts of certain authorities. Whether or whatever is legal or illegal is so because it was declared so by the legal authorities, okay. The ultimate touchstone, therefore, of all legal statements are the acts of these legal authorities. It is because the courts have defined the terms in a certain manner, whether these agree with moral meaning is irrelevant. Okay. So, now the legal rights, there are certain kind of legal rights which are there. For example, you cannot marry a girl if the girl is below 18. Now, this is a law and this has been given a legal status. Now, in certain customs and traditions, it was regarded that the girl could have been married at the age of 13 or 15 or whenever the family wants. This was a tradition which was continuing, but the law does not specify that, even though it was a tradition at some given point of time. So, then we say that the legal law does not mean that they are morally also correct, or legal law does not mean that whatever has been happening morally will definitely be legal. Okay. So, what are moral rights? In ordinary language, we use the term right in at least two ways. We say that someone has a right to something, and we also say that someone has a right to do certain things. Okay. In the first instance, to say that I have a right to something means that the other person is obligated or has a duty towards me. Okay. If I say I have a right to something, I have a right to learn how to drive a car, which basically means that the other people around me are obligated not to stop me from learning the car. Okay. In the second instance, to say a person has a right to do something basically means that person is morally free to act in a particular manner, which would mean that I am morally free. I have certain conditions existing for me to learn how to drive a car. That basically means I have a car and I have the roads being provided by the state for me to learn how to drive. So, then that is basically a morality of that concept. Okay. Now, what are exactly these rights, moral rights, which we are basically learning? Like the theory of natural rights, moral rights emanates from human reason. It particularly relies on human beings' sense of right and wrong, good and evil. It is based on accepted moral values in the society. Basically, its basis is morality. Now, morality, though we know, is very contested, but to say that I cannot kill somebody is particularly morally right. Yeah, I should not kill somebody. So, that basically means that this would be right across the world. We cannot say that morally it is right in some areas and in some areas it is wrong. Okay. So, again it is based on human reason. Okay. If it is said that particular person should be let alone to pursue or whatever he wants to do in life, he should be able to do, but that does not mean that he can go and kill somebody. So, then we say that there is a moral aspect being connected to it. It is believed that despite of belonging to different cultures and the conception of right and wrong, it is hoped that human beings would think alike on moral questions. Okay. It is a moral duty not to kill an animal, okay, not to hurt an animal. Now, this should be morally correct across the world. Okay. Exponents of theory of moral rights like Immanuel Kant tries to bridge a connection between moral realm and political legal realm. He argued that the reason is distinctive feature of a man and hence each human should treat its fellow members as end in itself, and if the person had the good will, he would respect others' end. Since this is not present in the state of nature, and that this is the reason we get in political legal realm to protect the moral rights of the man. Now, he says that in the state of nature, which was a state of war, people were basically going against or killing each other. But according to Immanuel Kant, he says that every human being should have this particular morality within them, that they should treat each other as particularly ends in themselves, which basically means that individuals should be dignified, they should be particularly observed with dignity as brotherhood, and hence he says that this particular part, since people were going against each other in the state of nature, so we required this political legalistic right if that was not the case, we would not have required that. So then he says, one, on the basis of morality, we have basically accepted this fact that it is wrong to kill somebody, but it would require certain kind of political legal status for it to actually being implemented in the society. Now, there is another author called T.H. Green who believed that rights of a man do not emanate from law, but from his moral character, as every individual is impelled by his moral consciousness. Now, this can be equated with the idea of dharma, which says that particularly if you are ruled by dharma, if you do the right thing, then particularly you would not require even this rules and regulations, but dharma itself will be a rule for you. So that is what exactly T.H. Green is also saying, that if you are ruled by your moral consciousness, then you would not require this legalistic conception of rights. So that is what he says, that this conception of right is something not which is basically coming from a legalistic point of view, it should basically come from the moralistic point of view. Okay. Now, we just discussed what were the types of rights based on their sources. Now, we will talk about the basis or the nature. Okay. Now, civil rights are basically those rights which we require as to have a dignified life. Now, what are those? Right to life, right to liberty, equality before law, right to property, abolition to untouchability, right to freedom of speech and expression, right against exploitation. Now, these are all the rights which are basically based on certain kind of nature, which is that human beings need to have a dignified life, and in order to do that you require certain kind of civil liberties, which are these. Okay. Then you have political rights, which is right to vote, right to contest elections, right to hold public office, right to criticize the government, and right to elect the member of the parliament. Now, these are all the political rights which are particularly there as compared to the civil rights which are there. Okay. So, these are the type of rights which are based on the basis of nature. Okay. Now, let us particularly go on to the theories of rights. Now, these are basically different perspectives and theories which has come evolve over the period of time to tell us what exactly rights are and why should they actually be given to the human beings. Okay. Now, we will start with the conventional theories of rights, which basically are these. Okay. Now, these are natural rights, moral rights, legal rights and historical rights. Now, we have basically talked about moral rights and legal rights in the previous slides. So, let us just focus upon what are natural rights. Now, John Locke was basically the proponent of natural right, and these rights ensure from the dictates of human reason, their validity can only be confirmed through natural right. That basically mean that the grounds of justification of these rights is that they have been taken by the natural law. Okay. Or for that matter, they are required when it is said that you are a human being and right to life is something which is very natural to you. Okay. Now, another conventional theory of rights are historic rights. Now, there are certain kind of rights which history provides us. Okay. Now, exponent of this is Edmund Burke. Okay. The grounds of justification of these kind of rights is conception of rights change over the period of time, therefore are not fixed rights. Okay. So, he says that there is no particularly fixed conception of rights, which basically means that a right which has been accepted today does not mean that it would be accepted in the future. It is the same as the theory of justice. Something which are considered just in contemporary times might not be considered just in the coming future. So, similarly, certain kind of rights which has been given, for example, if you remember, then when Indian Constituent Assembly was being made, before the constitution actually came into being, the Constituent Assembly, when it was to be elected, the elected or the electorate was basically people who were basically from either the property class, that means either they had property or they were educated. Okay. Only these two people were allowed to vote. So, that means that the right to vote at that time was only either with the property class or it was basically with the intellectuals. That means that not everybody had that right. So, again, does that mean that that right did not evolve over the period of time? No. So, when the constitution came, everybody was given that right to vote. So, that is exactly, particularly Edmund Burke says that this conception of rights change over the period of time. Okay. Now, let us see the utilitarian theory of rights and what do they have to say. Now, utilitarian theory of rights were presented by Jeremy Bentham. If you remember, I discussed who is this Jeremy Bentham. He is basically a utilitarian, which basically means that his notion of what or how the society should work is considering greatest happiness of greatest number. Only if that can be ensured, then only we will be able to particularly provide people with liberty, equality and fraternity. So, what he says is that he was of the view that legal makers should design rights in such a way or in such a manner that would fulfill what he called the principle of utility. Okay. Now, Jeremy Bentham is coming from the legalistic notion of rights. That basically means that there is nothing intrinsic in the human nature that rights should be given to them, but he is coming from the point of a legalistic angle, and he says that all these rights should be basically made or created in such a manner by these legal practitioners or policy makers that it should ensure the principle of utility. Now, what is this principle of utility? It basically means that the property in any object whereby it tends to produce benefits, happiness and advantages and prevents any mishappenings, pain and sufferance. If that party is a community, then that, and if that party is an individual, then that. Now, Bentham is saying that this principle of utility is basically that if something is giving you happiness and something is giving you satisfaction, then that right should be given to you, whether as an individual or whether as a part of the community. Okay? And anything that is giving suffering and anything which basically gives you unhappiness, then that should be taken away from the society. Now, he basically, as I told you, goes by the saying greatest happiness of greatest number. Now, the problem with utilitarian is that one, you cannot measure happiness. It is impossible that you can measure happiness on some particular scale. Secondly, ensuring greatest happiness would definitely mean that you are creating a certain section of society which would be marginalized, because here you are trying to promote majoritarianism. Then it would basically mean that we are promoting unjust social order, we are basically promoting inequality. Okay? So, that is why utilitarian theory of rights can never be accepted on the basis of greatest happiness of greatest number. Okay? Let us move to libertarian theory of rights. Now, this particular theory of rights was given by Robert Nozick. I am sure now you must have heard his name from my mouth. He has basically written a book called Anarchy, State and Utopia, and he says that whatever patterned and end state conceptions of justice are, for example, that is patterned, the points of distribution of resources are based on certain kind of principles or patterns, or particularly the second part, which is the end state principle, which is basically means that conceptions that seek to attain a certain kind of goal via a certain distribution of resources. So, he has used these particular two terms where Norbert argues that these conceptions of justice, whether they are pattern and end state, the former are the conceptions of justice that seek to implement a distributive scheme according to some agreed pattern or principle, which I just told you, whereas end state tries to seek to attain certain kind of goal. Okay? Now, what is important here is that each individual has the right, and in a particular and certain property rights that are absolute in character. That means that no amount of occurring of the society by it can justify infringement of this right. Now, Nozick basically figures at any point of contention you can have, that whether you want to distribute the resources on some agreed pattern or whether you want to secure a certain kind of goal, but in both these circumstances the right to property should be particularly designed in such a way that it cannot be infringed or taken away by the state. So, you should be given the right to property, and state or any other person should not have particularly the reason to take away if that particular property is acquired by fair means. So, he says that right to property is an intrinsic right and state has no reason or it can provide no justification to take it. Okay. So, then he calls this theory an entitlement theory, where the property rights are just if they have been acquired by fair means and a person is entitled to transfer this entitlement by just means. So, one, if you have acquired this right by hard work, then you are entitled to it. You can also transfer this right because you have been entitled, but all this should be done in just and fair manner, and if both these things are done, then no one is entitled to take this holding. Now, if you see, then Nozick would be totally against the concept when the right to property was removed from our fundamental right, though it still is a constitutional right, but it was removed from the idea of fundamental right. Okay. Now, let us assume human rights, which has gained much more importance in the contemporary world. Now, what are these human rights? The main source of contemporary concepts of human rights is Universal Declaration of Human Rights in 1948. Now, UDHR basically gives a extensive list of these rights which are considered as human rights. Okay. And when we read this, you will realize that these human rights are not always political rights or legal rights, but these are rights which as humans we are entitled, and these rights are basically being universally accepted across the globe, whether as a citizen, whether as an individual or whether as a community. So, what are those? First is the security right, which prevents humans from crimes, torture, murder or rape. Okay. Protection of freedom, freedom of speech, belief, association and thought. Okay. Political rights that protect people's right to vote and their participation in political processes. Due process of rights, that is protection against particularly abuses of legal systems such as imprisonment without trial or excessive punishment. Okay. Fifth is equality rights, which protect equal citizenship, equality before law and non-discrimination, and last are the welfare rights. So, in totality, human rights are political norms dealing mainly with how people should be treated by their governments and institutions. They are not ordinary moral norms applying mainly to interpersonal conduct. Okay. Now, these are the kinds of rights which government should inform that they are giving to the citizens. Now, if you remember that UN, which is United Nations, declared that if particularly a country is not protecting its citizens or people living in that country from genocide or are basically promoting crimes against them, then particularly UN will interfere, which basically comes in with the responsibility to protect. So, UN declared this responsibility to protect in order to ensure these human rights. Okay. So, there are these are just few of them, which basically means that particularly human rights are not moral rights or political rights or legal rights, but rights which as humans every country should protect. Okay. Now, what is the debate on these rights particularly, and what particular perspectives are there when we talk about what kinds of rights should be there or attained by the country or protected by the country. Okay. Now, the first particular perspective is that of the communitarian perspective. Now, this perspective is against this universalism of rights. Okay. Now, they critique that the notions of rights on the grounds that they take the individual as the unit for distribution of resources. Okay. Communitarians argue that individual is not abstract category but is deeply embedded in his or her culture. Hence, group identity should be taken into account rather than individual. Now, communitarian has a problem, or this particular group has a problem when we say that individual is taken as a unit for distribution of rights. Okay, that individual has been given much more prime importance than the community rights. Okay, if for example you have a conflict between, say, right to property, though it has been removed, if for example it was a fundamental right and there was a conflict in terms of giving religious rights, I am sure that right to property, which is individualistic right, was given much more importance than particularly the community rights. And that is also what happened in India, when in order to promote the development of a larger sections of the society which was underprivileged, certain amount of lands were taken from the wealthy class, and it arose to a lot of cases coming up in Supreme Court. So, that is why communitarians say that no, individual rights, because individual is a part of a community, individual rights should not be given so much importance, but community rights or identity within that community should be given importance. Okay. Now, particularly authors like Michel Sander and Walzer talks about that liberalism rests on a series of mistaken meta-ethical views. For example, the claims of justice are absolute and universal. Hence, commentarians argue the liberal politics of rights should not be abandoned for politics of common good. Okay. Now, here Michel Sandel in his book talks about liberalism and limits of justice, where he is basically saying that even justice, which is regarded as absolute, that all particular countries across the world should follow certain principles in order for the society to become just, or for the society to actually move towards something called justice. And similarly, they also say that these rights which has been given, they should not be used in terms of universally accepted proposition. Why? Because they say that, they argue that liberal politics of right should not be abandoned for politics of common good. Okay. Michel Walzer argues that the principle of rights and justice is more a matter of cultural interpretation than of a philosophical argument, which basically means that what people are due to, or what as individual, or what rights as individual they should have, is not so much importance as particularly the cultural interpretation of that particular rights, which can only happen if we view individuals as a part of a community, as a part of the group. Okay. So, then you have something called multicultural perspective on rights, which is basically starting from this idea that community, or the particularly individual who is a part of this community, is much more important than the individual itself. They have criticized the idea of universal citizenship, in which each person is treated with equal concerns and respect, can no longer be easily identified with a program of uniform rights. Okay. They believe that the idea of universal citizenship is based on the idea of difference blindness, which multiculturalists argue is not real but formal. For multiculturalists, real equality of rights is not measured through uniformity, but by keeping in mind their social and cultural locations. Okay. So, now again multiculturalists are also coming from the same point of view, that particularly these rights which are there can never be uniformly applied. Why? Because in every particular community or society there are some kind of difference which is there, and these difference can be, for example, in US, if you have racial discrimination and there is a minority of people who have been discriminated on the basis of color, in India you will see this discrimination happening at various levels, whether it is caste, whether it is color, whether particularly it is economics. Okay. Now, in order to remove this kind of discrimination, we need to have rights. So, that is why we also see that in our constitution you have certain kind of rights for the minorities, you have certain kind of reservation, grants given to the minorities, or special status. For example, that the state of Jammu Kashmir was given a special status because it was considered to be a land which had gone over so much, and also we see that that particular state which is called Jammu and Kashmir had its own constitution because it was looked from a difference point of view, which basically means that it cannot be ruled or it cannot have the same rights which the rights as Indian citizens everybody had. So that is why they had their own constitution, but over the period of time it was removed when it was realized that it is time for that now. So that is what multiculturalists say, that this uniformity, they have a problem that the rights cannot be universally applied. They would not succumb to certain kind of difference principle which is needed. For example, certain kind of rights would be needed for Indian women, the similar kind of rights might not be needed in Western countries. Okay. Now coming to the feminist perspective, feminists follow the same lines as communitarians, that principles of justice or rights should be understood from the point of group perspective, as it plays a crucial role in their minds. Now this is exactly what we are trying to say. Now a very important feminist is Irish Marion Young, and in her article The Ideal of Universal Citizen provides three meanings of universality. Now all these three perspectives have the problem that why do we see rights particularly from the point of view of universalism, that they can be universally applied. So she says that universality as inclusion of all in full citizenship, which basically means that we are all giving citizenship. Universality as a focus on common good defined in terms of what citizens share rather than what divides them. So basically universalism is being applied on the basis of what are our shared values, and on those basis rights are given rather than how different we are from each other. The third is universality as equal treatment, defined as the same treatment without the regard to group differences. Again, now we know that there are different groups in the society. Now recent one is LGBTQ. Now if we say that certain kind of rights which are given to say women should also be given to the same group, it would be unjust. Why? Because their rights, their demands are different, their needs are different. So rights should also be given to them in terms of their group difference, and this is exactly what even the feminist has a problem, that the uniformity or the universalism which these human rights are promoting does not specify the certain kind of group rights. Okay. So the attempt to realize the ideal of universal citizenship should lead to debate between commonness versus difference and put some groups in disadvantageous position even when they have equal citizenship. Okay. So the solution which Young proposes is group differentiated citizenship, which basically particularly mean that even if we have given equal citizenship, which would not mean that they can actually use their rights, because what is required is that different groups should also be given different kind of citizenship according to their own identity. Okay. So feminists believe that social and political system based on individualistic perspective of justice are highly biased because they are shaped by dominant individual male and not by women or any other marginalized groups. So that is basically what we are trying to see here, that from the point of rights, of how rights should be given, what are the kinds of rights should be given, or particularly how do we actually make this world a better place through promotion of rights, is basically has succumbed to different perspectives, and we have seen that these perspectives are mostly focusing on not universalism but in very particular differentiation. So again, to have one particular definition of rights just as the other concepts of liberty, equality and justice is probably won't do just to providing rights. So what most of these perspectives talk about is culturally, multiculturally or ethically or particularly group differentiated rights, which are very important in contemporary world, where we see these groups coming up not as individuals but as groups. Okay. So, I think by the end of this class, you will be able to analyze what is rights, what are the different perspectives of rights, what are the theories of rights, and particularly why do we require to change our perspectives on rights in generality. I think this class would be effective for you to analyze that these rights are not just what I can do and what I cannot, but probably the kind of evolution it has taken place over the period of time. That's it for now. Thank you.